One of the big changes in the new rules of professional conduct is with respect to the duty of client confidentiality. Now, while a lawyer may not advertise his or her legal services or practice with lawyers from other states, probably most lawyers will at some point in their legal career face an issue involving client confidentiality. And the changes with regard to the rules are fairly significant. First, the scope of the information protected by confidentiality is greater with the new rules. Under the old Rule 1.6, protected information or confidential information was considered to be confidences or secrets. Confidences were defined as those communications that were protected by the attorney-client privilege. Secrets were generally defined as anything that the client communicated to the lawyer, he or she wanted to be kept secret, or anything that would be considered embarrassing or detrimental to the client that the lawyer would know should not be communicated to anyone other than the client. For the classic example of a secret was a client who was having an extramarital affair. The new Rule 1.6, in keeping with the ABA model rules, defines confidential information as information relating to the representation. So clearly this information is much broader than information that's protected by the attorney-client privilege. As noted in Comment 3 to Rule 1.6, the rule applies not only to matters communicated in confidence by the client, but also to all information relating to the representation, whatever its source. So the information doesn't have to come to you from the client in order to be protected. It could come to you from a third source. Let's take an example. Let's say, for instance, you represent a client and on behalf of the client you are about to engage in settlement negotiations. The client is being asked to pay a sum of money to settle a matter. In accordance with your representation, you then communicate with a representative of the client's bank who provides you with information about the client's bank accounts and information about the general financial condition of the client and indicates to you that the client's financial condition is not good. While this is not information communicated to you by your client, under the new Rule 1.6, it is information that would be considered to be confidential. It is information relating to the representation. And so therefore it should not be the subject of cocktail party banter by you. Now, before you start to panic, the new rule does allow lawyers to reveal information that's necessary to carry out their representation. Lawyers are always impliedly authorized to reveal that information that's necessary to carry out the representation. So, for instance, returning to our example, if you are in settlement negotiations on behalf of the client, you could disclose the information that you receive from the bank about the client's financial condition, particularly if it would help your client, if it was in the best interest of your client to make that disclosure. Those types of disclosures would be viewed as being impliedly authorized under Rule 1.6. The new rule, like the old Rule 1.6, does allow for exceptions to the duty of confidentiality. Lawyers are mandated under Rule 1.6c to reveal information relating to the representation of a client to the extent that the lawyer reasonably believes necessary to prevent certain death or substantial bodily harm. It no longer matters who intends to commit the act resulting in the death or substantial bodily harm. Under the old rule, it had to be the client. Under the new rule, it doesn't make that distinction. So for instance, let's say if Illinois were to adopt the death penalty or reinstate the death penalty in Illinois, and if you were a lawyer who had information that would exonerate another individual that's on death row and about to be executed, even if that person was not your client, but you had information from other sources and confidential information, then you could conceivably, or you should conceivably reveal that information. And that is a mandated disclosure. So lawyers should reveal any information, confidential information, if the lawyer reasonably believes necessary to prevent certain death or substantial bodily harm. Obviously, the lawyer needs to have a reasonable belief, and the death needs to be certain death, and the bodily harm needs to be substantial bodily harm for the lawyers, for the mandate to occur. The rule also provides for permissive disclosure in certain circumstances. So for instance, lawyers are permitted to disclose confidential information to obtain advice about the compliance with the new rules of professional conduct. The new rule expands the circumstances of permissive disclosure, however, and these changes were adopted in the wake of the numerous corporate scandals, including the Enron scandal. So Rule 1.6 now allows for disclosure of information relating to the representation of a client where the client engages in fraud and has used the lawyer's services, and the fraud results in financial injury, or to prevent or mitigate the injury that's already occurred from a client's fraud. The reasoning behind this exception to the rule of confidentiality makes sense. It's to allow the lawyer to rectify a wrong for which the client has used the lawyer's services.